Good morning, everyone, and welcome to our presentation this morning, our virtual roundtable discussion around the legal case for supporting gender diversity at work. For those of you who are on the line who don't know me, my name is Amanda Nash, and I'm a labor and employment lawyer practicing out of the St. John's, Newfoundland office. And I identify as she, her. I'm going to be joined by my colleague, Brittany Keating, who also practiced labor and employment in the St. John's, Newfoundland office, and she also identifies as a she, her. The topic for today's session is the legal case for supporting gender diversity. Gender diversity is not a new topic. It's something that's been going on in the human resource world and in life in general for many years. However, it's something that is coming to more light in the context of employment and as being something that we're being asked to provide advice on more frequently. And in an effort to be proactive, we encourage employers to take action in order to prevent legal liability associated with it, as well as to do what they can to support employees in the workplace. So today we're going to talk about why employers have a legal obligation to create safe and healthy workplaces, what steps employers can take to provide or to support to a gender inclusive workforce, how to fulfill their legal obligations, and how your failure to do so can lead to legal liability for employers. Next slide, please. Okay, so we wanted to have a little segue into it because there's some misunderstanding or misconceptions or just lack of awareness around exactly what gender diversity is. I certainly don't proclaim to know everything there is about gender diversity as a female identifying woman. However, the point of the presentation and the message that we really try to hone in with our employer clients is that employers should have a basic understanding of what gender diversity is, as well as to be open to learning more as you encounter it and as you develop your diversity and inclusion policies and things in your workplace. So just at a very high level sense, gender diversity covers a range of gender related identities and expressions. It's included but not limited to being transgendered, gender nonconforming, gender fluid, intersex, and two-spirited. Um, there are other related concepts that we also talk about, and there's a publication that was recently updated. It's Take Pride. It was revised in recognition of Pride Month this month, and it's 5 ways employers can support gender diversity. It has a very high-level overview of what gender diversity is, as well as some excellent resources. If anyone's interested in the publication and can't locate it on the website, we can certainly provide a link to it for you. But in that, it does talk about some of the 10 most commonly referenced terms, some of which I'll go through. And so the difference in sex and gender and things that are sexual orientation and things that are referenced in the human rights legislation, sex identifies the strictly biological description of a person. Gender is much broader than sex, and it is how a person encompasses their biological nature, but also their cognitive and social aspects as to how they identify and express themselves. So then when we talk about gender identity, that's how a person feels about themselves, how they see and feel about themselves. Gender expression, on the other hand, is how the person expresses or presents their gender, and they don't always match. So cisgender is a term that references a person whose gender identity and their biological sex match. However, there are others, in between. And so we have to be aware of all this and know that everyone is different, and it's important to know. And so as part of that, there are lots of things that we will talk about through the presentation, and refer you to resources as to where you can find out more about this or get training for your workforce. However, it's just important to note that it's a learning curve, and it's something that continues to evolve. And the more that we bring it out proactively, the better understanding and acceptance there will be around it. And yeah, next slide there, Yara. So as I said, this is not a new issue. For years now, gender diversity and inclusion have been kind of umbrellas in human resource strategic plans. There is a lot of support or literature around the fact that gender diversity workplaces are more productive, and that employees, often choose to go to work at places that are more diverse, and clients sometimes look to your policies on diversity as to whether they want to engage with your business. So having gender diverse policies has always been something that employers should be aware of. Now, we're seeing that the newest business case that we see is that employers are facing a labor shortage. Recruitment and retention is much more difficult in today's market, whether that's because of the aging population, immigration slowdowns because of COVID, and then the great resignation that happened, post-pandemic, with people reevaluating their careers. Employers are really struggling to retain and recruit workers. And so we're encouraging employers to kind of cast their net wider when they're recruiting. And if you joined McInnes Cooper for the webinar last month, you would have seen that colleagues of ours discuss recruitment strategies, some of which addressed diversity and inclusion. And I believe that's available on the web, so you can check that out if you missed it last month. But in that session, they talked about different strategies. And the real point of this is that while you may not be aware of the fact that your current recruitment practices, they may be unconsciously excluding certain people. And so it's not that you've intentionally not been seeking out a gender diverse population in your workforce. It's that you may not be getting applicants based on either your job descriptions or your job ads, if they don't include gender inclusive language, or if your website and recruitment or marketing materials around your business don't include references to what you do as an organization to be more gender inclusive. And by that, you may not be getting candidates who wouldn't feel comfortable going to work with your organization, either because they are concerned that they wouldn't be accepted because they identify differently, or you may not be able to recruit people who want to work in a gender inclusive workforce. Next slide, please. So we're labor and employment lawyers, so we always talk about the legal case for doing something. There are lots of moral reasons for doing it. However, the focus of this presentation is going to be the legal case. So on the slide here, we have 4 areas of the law where gender identity and expression kind of touch on. 3 of them are really going to be the focus of our presentation, as even though there's a reference there to criminal law, and that criminal law has been updated in the last number of years to reflect gender identity and expression. It's not really as applicable to employers, but it is worth noting that in 2017, at the same time, the Canadian Human Rights Act was amended. The Criminal Code of Canada was amended to make it a criminal offence to advocate or incite hatred. So it's made a hate crime against an identifiable group, and the definition there was expanded to include um, uh, persons who identify or have a different gender identity. And so crimes against persons as a result of or because of their gender identity is now constitutes a hate crime under the criminal code. With respect to human rights laws, which you're likely much more familiar with, every jurisdiction has a slightly different definition or of what gender identity is or gender expression, but they all include prohibitions based on sex and some form of gender identity or expression. And so um, employees or applicants who feel that they have been treated differently or are discriminated against or suffer harassment in the workplace as a result of their gender identity or expression can file human complaints with their respective Human Rights Commission, and the employer would have a duty to defend them then. With respect to occupational health and safety laws, recently over the last couple of years, again, almost every jurisdiction in Canada, or likely by now every jurisdiction in Canada, has amended the occupational health and safety legislation to include specific prohibitions against harassment and violence in the workplace. And this would include harassment based on gender identity and expression, although in the occupational health and safety context, as opposed to the human rights context, it doesn't have to be exclusive to a prohibited ground. The harassment requirements or prohibitions can be much wider. Um, However, it still would be included under that, and so your employee has the ability to either file a complaint with the Human Rights Commission or could file a complaint with the Occupational Health and Safety Division in your province to say that they have not been provided a safe and harassment-free workplace. And then we have the much broader category of employment law, and that really should say employment and labor law, because if you are in a unionized workplace and your labor force could file grievances where issues around gender identity or expression, whether that is discrimination on the basis of gender identity or expression, or an impact in their employment, whether they feel that they have been, denied a benefit or laid off or terminated because of their gender identity or expression, that could proceed through the grievance procedure. And in the non-unionized context, employment law is engaged with respect to gender identity and expression because unfortunately, in many of these cases, employees end up being terminated and they believe that their termination is on the basis of their gender identity, or the workplace has become poisoned, or the employee no longer feels comfortable working in the workplace and they quit and they claim constructive dismissal. And claims for wrongful termination or constructive dismissal can proceed through the civil process in the courts. So there are lots of avenues. And next slide. I think I may have already said some of the next slides. So again, these are the different areas that are particularly relevant to employers and the avenues upon which complaints can be filed, and that employers may find themselves having to defend their actions, and it's where the legal liability to employers will arise. Okay, next slide, yeah. So this, even though the case law is relatively limited in this area, it's not to say that discrimination has not been occurring or that employees have not been adversely affected as a result of their gender diversity in the workplace. However, the case law takes a lot longer to catch up. And so we do have some real life examples. Most of these examples arise out of the human rights context because that is oftentimes the easiest process for complainants. They simply have to file a complaint with the Human Rights Commission in their jurisdiction, and they don't need a lawyer to do that, and the commission can guide the process. There's no cost for complainants to use that process, and it's the most commonly known avenue for people to pursue because it's adverse impacts in employment based on gender identity or expression has, I guess, originally been tied to the human rights process and discrimination in the workplace. However, over the next number of years, I would suggest that we will likely see more and more of these cases, or at least an obligation for employers to investigate to proceed through the occupational health and safety process that's been implemented. And thanks, Yara. Um, Sorry, just if we could just go back 1 second and go back one more, actually. Sorry, I'm getting ahead of myself. Um, so yes, the human rights process is the most typical, and so that's the cases that we're going to discuss today fall there. I believe that OHS will become more and more prominent, and so far there have been few that we could locate where this is processed through the grievance procedure, and few or even less that we've been able to find where it's processed through a civil lawsuit. However, when we do go through the cases that have went before the human rights commissions or tribunals that we're going to talk about today to illustrate some of these as real life examples, in each of those cases, when we're reviewing it, the point that was made out, while there was determinations made in those cases under the human rights process, the employee in that case could have equally sought out recourse in either of the other avenues. So employers have to be aware of the fact that they can be brought in either. So we can go ahead again now, and one more. So there's 4 cases I'm going to talk about, and typically I would just go through the 4 cases, tell you what happened, give you the facts and the outcome of the case. In each of these cases, I'll give you a spoiler, and that is that in each of the cases that we talk about today that we found where there was a claim based on gender identity, or one of the cases has to do with sexual orientation. Discrimination was found, and remedies were awarded against the employers. However, the way the case law is organized in this time, or in this session, is to talk about the topics or the reasons why liability was found. The first is gendered nicknames. And so in the case of Nelson Goodberry, which is a very recent case, pardon me, out of Ontario or BC, and it went all the way to the Human Rights Tribunal. It was a person who was working in a restaurant, and the bar manager, or the complainant in the case, was they were transgendered, and they preferred the pronouns they or them. When they went to work, they made it very clear to everybody that that was their preference. However, there was a bar manager who continually refused to respect and to follow the preferred pronouns. And they also went further and used gendered nicknames. It was sweetheart, sweetie, and honey. I kind of, had a little bit of reflection on this, and I said, that's something that we encounter at, in the Maritimes, in Atlantic Canada, definitely here in Newfoundland. If you go to the grocery store, you can be called any wide variety of nicknames. You know, Historically, they've been considered to be terms of endearment, and there has been no harm intended by them. However, that's changing. And when particularly when somebody expresses that they identify a certain way, and that's not respected, that's going to be problematic in the workplace. So the British Columbia Human Rights Tribunal in this case found that the nicknames of Sweetie, Sweetheart, and Honey were typically used in reference to a woman or a femme identifying person. And so, because the complainant in this case did not wish to be identified as she, her, and they wish to be identified as they, them, that by continually referring to them by one of these gendered nicknames, that they were disrespecting the person's choice and their gender identity or gender expression, and that what it indicated to the complainant was that the person who was saying the nicknames was, considered them to be a woman and was referring to them as a woman or a female identifying person, which they were not. So what the Human Rights Tribunal in that case said is that, while they may have been terms of endearment and they may be appropriate in a familial, a romantic relationship type setting, there is no place for these type of nicknames in a professional setting. Um, and yeah, so next slide. Um, in the same case, as I referenced, there was a misuse of pronouns. Similarly, in another 2021 case, only out of the Ontario Human Rights Tribunal, the case of Ian and Gallagher's Bar, that actually involved 3 complainants. And in those complainants, or in that case, the 3 persons identified as they, them, and they were not respected. That case unfortunately went a little bit further, and there was some homophobic slurs. They were referred to as being trannies because of their transgender, and the employer's response was not sufficient, and those employees all ultimately didn't feel safe in the workplace, and they didn't feel respected, and not having the issue addressed, they all quit and filed human rights complaints. In those human rights complaints, they alleged, discrimination in employment on the basis of their gender identity, and discrimination was found against them, or against the employer in that case, and they were awarded back pay, or pay from the point that they quit up until the point that, in this case, each of the complainants returned to school. So I think there was $6,000, $2,000, $2,000 awarded in lost wages and benefits, and then each of them received $10,000 in damages as a result of the injury to their dignity for the failure to recognize their pronoun use. I should have also mentioned in the prior case, the award was $30,000 in damages. So not insignificant damages. The next slide, please. Poison and toxic work environment. This is not just relevant to these 2 cases here, but what it goes to show is that it doesn't have to be just one incident, and if that is or is not discriminatory, then that's the end of it. A poison or toxic work environment can be established over time, and it's the sum of all the parts. So, over time, has the work environment become, poison or toxic to the point where the person can't work there, or that the toxic work environment itself is what was the adverse impact on the employee in their employment. So we haven't talked yet about the Vanderputten case. The Vanderputten case, it's the first case that we could identify. It's from 2012, so it's a little bit dated in the sense that I think that if the same case was decided today, it would have been a little bit more harsh, or the outcome would have been a little bit more harsh in that case. So the complainant was transitioning from male to female while working, and they wanted to be identified as she, her, because that is how they identified, and they were taking the additional step to have the transition surgery. So in that case, the employer continued to treat the person as a man, and they expressed that they were going to continue to do so until they became a woman and had the gender or the sex confirming surgery, and had medical documentation to support it. So really, in that case, the employer wasn't recognizing the employee's gender identity or expression. They didn't, respect the person's gender identity, and basically said they weren't going to respect it until they made the transition, and until they became a woman, they would be treated as a man and were required to use the male, staff facilities, washrooms, change rooms, etc. Um, and there was a violation. Um, in that case, the employee was actually terminated. Um, the employer alleged that they were terminated because of their insubordination and attitude in the workplace, and etc. And we'll actually get into that more in the next one of the next slides. But for this point, for the poison toxic work environment, the Ontario Human Rights Tribunal found that the workplace and the requirements, or the continued refusal to accept the employee's gender identity, um, created a poison and toxic work environment, which was significant enough that it attracted damages for the injuries to the employee's dignity, and any mental suffering that they endured as a result. In that case, it was about $22,000. Again, keeping in mind that was in 2012. The TM Manitoba case, sorry, I know I'm being a little slow here. The TM Manitoba case, we also haven't talked about that one yet. So this one is not specifically about gender identity, but it is fairly recent, and it has to do with sexual orientation, which is very, still very much related to this topic of discrimination based on sex or gender in the workplace. And so in the TM Manitoba case, the person was a gay man, um, and there was no real reference as to how he identified, or his pronouns, but he endured, or he experienced discrimination in the workplace, or he alleged he experienced discrimination in the workplace. He was alleged that he was subjected to nicknames, and slurs, homographic slurs, and even physical touching based on his sexual orientation. And that over time led to a toxic workplace. And that one attracted significant damages. It's actually $75,000 in damages to compensate him for his injury and dignity in the workplace. So in that case, he continued to work. There was no issue of termination, but the environment that he was subjected to day, was found by the Manitoba Human Rights panel to be very significant, and awarded significant damages as a result. Okay, next slide. Employment termination. So again, while these could have been brought in one of the other avenues through a court process, in each of these cases that proceeded through the human rights system, there were situations where employment ended. The Vanderputten, as I just alluded to, the person was terminated. He um, they were terminated because, or it was alleged they were terminated because of their insubordination and attitude, that they were in conflict, that they received numerous complaints about the employee's performance that were unrelated to their gender identity. Um, but the termination doesn't have to be only related to uh, the person's gender identity. Human rights tribunals will typically find that even if it is one factor, or if the decision to terminate is tainted by a prohibited ground of discrimination, then it would found to be an adverse impact. And in that case, it was. The Human Rights Commission did not accept that the termination was only a result of the employee's conduct, and that the decision to terminate the employee was tainted by the employee's gender identity or expression in the workplace, and really, I guess some of the employee's attitude or insubordination that the employer tried to argue was found to be related to the fact that the employee's gender identity was not being respected, and that the employer thought that they were being, causing conflict and being confrontational, when really they were just exercising their right and advocating for their gender identity to be respected in the workplace. Similarly, with Nelson, the employee in that case was also terminated. However, what's interesting about the termination, that case, it was a similar situation. The employer tried to state that the employee was being terminated because they had been insubordinate, and they elected to terminate, and that there had been a confrontation, a physical confrontation between the complainant and the other employee who was alleged to have been harassing or discriminating against the complainant. There was a physical altercation. The employer determined that, it wasn't safe to have them both in the workplace, and the employer elected to terminate the complainant because they were the newer employee and because they were still within their probationary period. And the employer believed that they could terminate the employee, without cause, without notice, because they were still within their probationary period, that there would be no consequence for the termination. However, the Human Rights Tribunal in that case made it very clear that you cannot contract out of statute, and that while the probationary period applies for the purpose of, the employment or labor standards, and the requirement to provide notice, that the probationary period did not negate any findings that the termination was tainted by the fact that the person or the conflict in the workplace arose as a result of the employee trying to have their gender identities respected in the workplace, and that they weren't. Next slide. So the employer response, this is my last slide, and then I'll stop talking, is that, in all four cases, as similar and as different as they all are, the employer response in each case was found to not have been sufficient. And so the employer's response is a very, very important factor going forward. It's what Brittany is going to talk about, in the next few slides in the second half of this session, that things can happen in your workplace that are not acceptable. Sometimes they happen unbeknownst to employers. But the moment that an employer becomes aware of it, or the actions that the employer takes to ensure that there is a safe workplace and that there is no discrimination, and proactively have policies in place to address some of these matters, or to provide the required training to ensure that other employees understand the need to respect gender diversity in the workplace, then the employers will be liable for their failure to act. And so it was very telling to see that in not one case was the employer response sufficient, and really highlights the need to be proactive. Okay, so the next slide, I think, is where Brittany comes in. I'm going to go off, but I'll be available at the end for questions.
Hi, everyone. So Amanda sort of walked through some case law that shows some examples of employer liability for failure to respect gender expression and gender identity in the workplace. Ultimately, it's the employer's responsibility to provide a workplace that's free from discrimination and harassment, and that's a safe and healthy place for employees to come to work. And the failure to provide adequate support for gender diverse employees will result in legal liability for employers. And so I'm going to talk about some of the tips that we can give to help avoid that liability and to help deal with issues around gender diversity in the workplace before it becomes a problem, before it becomes a complaint. Next slide, Yara. Thanks. So an employer has an obligation to take reasonable measures to prevent harassment and discrimination in the workplace. An employer's failure to respond at all or to respond reasonably to workplace harassment and discrimination by others can itself amount to or contribute to discrimination and harassment. So what's important from an employer's perspective is that you have a policy in place and that you've provided training to your employees so that you've taken reasonable steps to prevent discrimination and harassment, and that an employee has an avenue to raise issues when they feel they've been discriminated against or harassed on the basis of their gender identity or expression. As the board reiterated in the Nelson case that Amanda referenced, an employer is obligated to respond reasonably and appropriately, and they must investigate a complaint. So the human rights tribunals, they typically look at a number of factors when assessing an employer's response to these complaints, and those are listed on the right-hand side of your screen. The human rights adjudicators will look at whether the employer has a proper understanding of discrimination and harassment, whether they've treated allegations of discrimination and harassment seriously, whether they act sensitively towards the complainant throughout the process, and whether they resolve the complaint in a way that ensures health and safety in the workplace. So those are some things to keep in mind when you receive complaints from employees in respect of their gender identity and expression. And it's a reminder to make sure you do the work on the front end to ensure you understand what discrimination and harassment is when it comes to gender in the workplace, and that you've educated your staff and respond appropriately to situations when they arise. Next slide, please. So what should you do to support a gender diverse workplace and to support inclusion? And that's what I'm going to go through in the next few slides is some tips that you can do to help fulfill your legal obligations when it comes to gender expression and identity in the workplace. Next slide. So we are lawyers, not HR experts, and a lot of this really comes down to workplace culture, to people and culture. And so what's important is that you foster a workplace environment that is safe, open-minded, welcoming, and inclusive. a culture where gender diversity and inclusion is talked about, and that you don't just talk the talk, but you walk the walk. It's important to engage your human resources team or an external HR consultant if you don't have a internal human resources team to provide you with the tools you need to foster that inclusive work environment. We wanted to make you aware, if you aren't already, that we have a branch called MC Advisory that's separate from our legal services division that does provide this type of consulting to employers who need extra human resources support. And so you can look up MC Advisory on our website, but generally they do provide services in the area of people and culture, such as strategy and transformation, where they'll help clients develop strategies that prioritize people and culture-related processes, programs, and initiatives. That can include strategic planning, workforce planning, and employee engagement. They also work in design and development and provide tools necessary to reach your organizational goals. Leadership development, workplace policy drafting, training and development, and program and development in occupational health and safety and diversity and inclusion. So they can provide HR as a service as well. So if you feel you need more resources on this topic, certainly reach out to us or to MC Advisory to discuss those offerings. Next slide, please. The second tip is education, and I can't express this enough. It's so important to generally educate your managers and employees on gender diversity. And I would suggest frequent and repetitive training in this area is necessary because it is a constantly evolving area and it requires a lot of education and awareness. There are some great resources out there. I'd point you to the Ontario Human Rights Commission's website. Has a lot of really great resources that I looked at in preparation for this presentation, including a policy on preventing discrimination based on gender identity and expression in the workplace. It outlines some really good tips for dealing with this stuff and explains a lot of the common terms we talked about and how to effectively deal with issues in the workplace respecting gender identity and expression. So you need to learn the basics. What is discrimination? What is harassment, especially in the areas of gender expression and gender identity? The reality is that employers need to be comfortable being uncomfortable. People have a tendency to avoid situations where they're uncomfortable or uneducated about a topic. And, if you have a transgendered employee in your workplace, some employees and managers may feel like they're uneducated on this topic and they're uncomfortable addressing it in the workplace. And so rather than set themselves up to try to respect the individual's requests for a certain pronoun or name, etc., they tend to avoid the person because they don't know how to deal with it. And that's not going to get anyone anywhere. It's better to try and be open and willing to learn to help that person feel accepted. The more we talk about these things, the more comfortable employees will be coming forward with issues, and the more comfortable coworkers will be supporting gender diverse employees. And so you need to encourage your employees to listen to the individual with lived experience, to have an open mind and to respect their wishes. And make every effort to adjust your language and vocabulary to help them feel included. We don't have to understand their experience, but we do need to accept that everyone has a right to be addressed by their requested pronouns or their chosen name, and we need to be respectful of their wishes. And it's okay if you get it wrong. Apologize, correct yourself, and move on. What's important is that you make your best effort to use the pronoun that the individual has asked to be referred to by. And so training in the workplace, education and awareness is what will get us to a place where employees are comfortable with this. And that'll reduce an employer's liability. You need to know your legal obligations, and that includes the obligation to have a harassment prevention plan in your workplace, which is mandated by the Occupational Health and Safety Act, and to have a diversity and inclusion policy that that identifies channels for reporting for employees and a process for investigating complaints. And of course, as we've already talked about, it's so important to act when those complaints arise. You also may have a duty to accommodate transitioning employees. They may need time off for medical procedures or time off so that they can return to the workplace presenting in their new gender. You may need to make changes in the workplace to reflect their name change or pronoun change. And you may have to accommodate providing access to change rooms and washroom facilities. Another issue that also often comes up is the use of pronouns. And so we always recommend, learning about all the various different pronouns that individuals may wish to use and to familiarize yourself with those common pronouns. And we encourage you to go further by giving all employees the opportunity to select and display their preferred pronouns. And you see that from most organizations these days, that people display their pronouns in their email address or identify their pronouns when they speak to a group of people. And the reason we do this is because it normalizes discussions about gender. If a person has never had to worry about which pronoun others use to refer them to, gender pronouns might not seem that important, but for people who are constantly questioned or misgendered, the experience can leave them feeling excluded and alienated. And so if we include our pronouns in our email address, if we state our pronouns when we address people, it signals to trans and non-binary individuals that they belong, and it creates a safe space for them to be able to share their pronouns without feeling singled out or isolated. Next slide, please. So we're doing a poll here. It'll come up on your screen. If a policy that states female employees must wear blue golf shirts and a black skirt, male employees must wear a blue golf shirt and black pants. Is this policy okay? And you can answer the poll on your screen there. And the options are yes, maybe, and no. I'll just give a minute for the poll responses to come in here. All right, so most people said no. In my view, gender-based dress code policies are a thing of yesterday, and we encourage employers to get rid of them if they're still in place. You may be able to convince me in some situations that it might be necessary, but I find it very difficult to think of something off the top of my head where gender-based dress code would be considered a necessary bona fide occupational requirement. Limiting the female employees to skirts obviously creates a distinction based on gender, but it could also pose problems for transgender employees. It's difficult to come up with a true non-gender specific reason why a skirt would be required that doesn't fall back onto gender stereotypes. Explicitly distinguishing between male and female employees, and that's not just in a dress code policy, but in any policy or any action that you take in the workplace. If you're distinguishing between males and females, this could be seen as exclusionary because it doesn't account for transgender, gender neutral, or multi-gendered employees. We recommend avoiding gender distinctions in the workplace, full stop. Next slide, please. And the next step is to have gender diversity policies. We've talked about this a few times, but it's important to properly implement and enforce gender diversity policies and also visibly support gender diverse employees. It's one of the most important things an employer can do to support gender diversity in the workplace. having a policy in place is a starting point, and creating the work culture we talked about is the next piece. But the policy at least gives employees a place they can look where they're told what their options are, and that they're welcomed and supported in the workplace, that they have an avenue in the event they feel they're being discriminated against based on their gender. And so we encourage you to put a gender diversity policy in place if you don't have one already, and to refer to it frequently and update it as required, because this is an evolving area and things change, and it's important to reflect the most common and current practices in this area. There was a study by Harvard Business Review in 2016, which said that countering LGBTQ2S plus discrimination makes a corporation competitive on 3 fronts. And one of those fronts is recruitment. And Amanda talked about how recruitment is a real challenge for most employers these days. In a survey, 72 respondents, including non-LGBTQ 2S plus people, indicated that they're more likely to take a job where an employer supports LGBTQ 2S plus employees than one that doesn't. So it's a competitive advantage as well. And it's so important to show candidates that you are an employer that respects diversity and inclusion. Next slide. We also recommend that you review your existing workplace policies to ensure they're gender inclusive and they fulfill your legal obligations. When we draft legal documents for employers now and employment contracts policies, we avoid the use of gender pronouns as much as possible. We tend to say the employee or they, them, instead of she, he, etc., because it can be exclusionary to folks that don't identify with those pronouns. It often takes minimal revision to transform your policy into a gender inclusive policy. So you want to make sure your policies have gender inclusive language, but also that they have gender inclusive effect. I often hear people push back on the use of they, them pronouns, and people seem to think it's too difficult to use those pronouns or that they make no sense. However, we use these pronouns more often than we realize in a very natural way, and I think it's important to talk to your employees about that. If you don't know the gender of the individual you're talking about, you often use they and them as pronouns naturally. So if, for example, a cab driver was coming to get you, you didn't know if a male or female or otherwise, you might say, they're coming to get me, I'm going to meet them. It's very natural when you don't know someone's gender to say they or them. However, when we assume gender, we tend to use she, he, him, her. And so it's all about your mindset and making an effort to use proper pronouns. We encourage employers, when onboarding employees, to update employees on orientation programs to include discussion of discrimination and harassment, as well as gender diversity and inclusion right from the start, so that gender diverse employees know they're welcomed and respected and valued. The other thing is washrooms. That comes up a lot of the time. Employees have the right to use a washroom facility of their lived gender, regardless of their birth assigned sex. A washroom is a basic physical need at the core of human dignity, and an organization's washroom facilities should not negatively affect trans people. A trans person should not be required to use a separate washroom because others express discomfort or transphobic attitudes. Education and awareness will dispel these kinds of stereotypes. Depending on your workplace, it may be easy to convert your facilities to gender neutral ones, but even if not, if the employee is, for example, in but not yet completed transition, like was in the Vanderputten case that Amanda referred to, the employer is obligated to accommodate that. The Human Rights Commission in Ontario has a great best practice checklist that you can review on their website, which addresses these kinds of issues. I found it interesting that apparently the Ontario Building Code regulation now requires new builds and major renovations to have at least one universal washroom, and also permits single-use gender-neutral washrooms for everyone instead of separate male and female washrooms. And I think we'll see more and more of that as time goes on. It's important to look at your workplace and consider what adjustments you can make to accommodate people in your workplace when it comes to washrooms. And we encourage you to have transition guidelines that incorporate some guidelines for trans employees in your workplace policies. These guidelines should be flexible enough to allow individualization, but also meet the particular needs of the transitioning employees. They might identify who's responsible for helping a transitioning employee manage their work transition, what the transitioning employee can expect from management, and other guidelines for the workplace, including washrooms, restrooms, change room use. We encourage you to limit your requests for personal information in employee records where you're asking for an employee's gender or sex. If you don't need that information, you shouldn't be asking for it. And so you should consider limiting the amount of personal information you're requesting from employees. And as well, the harassment and discrimination complaint process and procedure that I've talked about multiple times. Next slide. It's also important to assist in workplace communications. One of the most crucial ways an employer can support gender nonconforming employees is to communicate to other employees in the workplace, but only with the employee's authorization. If you don't have the employee's authorization, disclosure of that information might itself constitute harassment. So, it's important to work with an employee who's transitioning to ask them what support they need and what communications they would like for you to make on their behalf to help ease their transition in the workplace. Next slide. I won't go through this in detail because I've said it multiple times, but it's important to ensure adequate education and training for your managers and supervisors and all of your employees to make sure everyone's comfortable with this. There's often a sense of discomfort attributed to a lack of education, or there may be grief surrounding some of the loss of an existing employment relationship between employees. There's insecurity about getting it right when you try to address someone with their chosen pronouns. So regardless of the source of discomfort, it's important for the employer to attempt to address those feelings and concerns through education and discussion. Next slide. And finally, complaint response. So it's imperative to respond to human rights complaints such as harassment and discrimination in the workplace. Failure to do so could result in a number of avenues of liability, which Amanda discussed, including OH&S violations, a human rights complaint for discrimination or harassment, or even a constructive dismissal complaint if the employee feels there's been a toxic workplace created by the employer's conduct. So make sure that you investigate complaints, you listen to employees' complaints, and resolve their issues in the workplace before they become litigation. Next slide. So if you have any questions, please write them in the chat box. I know we've gone right to 12:30, but I'm sure we could stick around for a couple of extra minutes just to get a few questions in if you have them. And as we mentioned at the outset, if you have a question you want to ask us directly, please feel comfortable to send us an email. We'd be happy to answer after the fact. And of course, if you want to reach out to either of our labor and employment lawyers across the region, we'd all be happy to help you. I wanted to point to our MC Legal Labs. There's a little description there on your screen, but also if you search MC Legal Labs on our website, you'll see that we give sort of customizable training workshops, which are led by our labor and employment lawyers to support continuous learning of your people leaders in the workplace. So these are fixed fee presentations that we can give on a variety of topics. There's a catalog you can look through. Two of those topics include a systemic approach to the duty to accommodate, as well as applying accommodation to emerging areas of human rights protection. So those are two topics that are related to this slide presentation that we could provide training to your workers. Next slide, please. We also have legal alerts and updates, which the link is there. You can subscribe to and receive these legal updates monthly when we send them out. And Amanda mentioned earlier, we do have one online that is 5 ways employers can support gender diversity. It's called Take Pride at Work. That's an example that's very on point with this topic, where you can get some guidance on how to deal with these issues in your workplace. Lindsay, do we have any questions come in through the comments box?
So we do have a couple of questions here. Our first question is around pronouns. Do you recommend companies have all employees put their pronouns on their work signatures? Now, I know that you touched on this during your presentation. I guess we'll just revisit for a moment.
Yeah, I mean, I think it's important to allow employees the option, give them the opportunity and encourage them, if they feel comfortable, to include their pronouns in their email signature. I think it's also important to provide education around that too. When you send a communication to your employees to say, we encourage you to identify your pronouns and your email address. And here's an article that explains why it's important to do that and why it's supportive to gender diverse employees to include your pronouns in your email address. So it shouldn't be forced is the important part, but it's good to encourage it, and especially for leaders in the organization to lead by example and include pronouns in their email signatures when they feel comfortable.
Perfect. Thanks so much for that. We've only got one more question here, and the question's around training. So what training is available for employers and teams to create awareness around gender diversity?
Well, we mentioned it. We have MC Legal Labs. There's some training in that respect. We can also provide training in respect to your particular gender diversity and inclusion policy. So if you have a gender inclusion policy, you could get training specifically on your policy. But MC Advisory, our other entity that sort of provides people and culture, would also have more specific training. There's lots of training out there that you can Google and search for resources, but it's important to have someone who knows a lot about this topic to come in and speak to your employees on it. You want someone that's educated in this area to really give good training on this stuff. Amanda, did you have any other ideas of training?
Yeah, so I just wanted to distinguish that there's different types of training that apply here. Some of the training will be to train your supervisors and managers as to how to respond appropriately, how to take it to receive a complaint, and what resources that they can provide, or to assist an employee where they go within the organization when an issue like this is raised. So there's training, no different than your duty to accommodate with respect to other, types of, whether it be a disability or a family status type accommodation. So employers need to provide training to their managers or supervisors, frontline staff. However, when it comes to the broader how to create awareness in the workplace and acceptance with respect to your gender or your diversity and inclusion, strategies as a whole, I would suggest that may come more from, a consultant type person like MCA Advisory or other, where they can provide strategies around communication, appropriate communication, whether, you might have a poster campaign in your workplace at different times. So different types of training can be offered by different people for different purposes, and one is not going to be sufficient. You likely are going to need multiple, and it's not just a one and done, tick the box. This is the type of thing that has to be refreshed as there are changes, but also just as reminders. in the workplace, if not annually, semi-annually, and can be incorporated into other training that you do. For example, with your occupational health and safety harassment training, to have a couple of slides on this to just get a plug in for it, to be able to show that you are aware of it, and that you want to do more. And it's very important to have this in place and to have your policies in place before an issue arises, so that if you do get a report that there's been an incident of harassment, or you get approached by an employee who is going through a transition, that you are already equipped to deal with it, so that you don't face the, an allegation that you have failed to respond appropriately.
So I think that's all the questions. That's correct, Lindsay?
Yep, that's all the questions for today.
Awesome. Well, we thank everyone for joining us. And as we mentioned, if you have follow-up questions, do not hesitate to reach out to us. And we look forward to chatting with you again in another webinar.
Great. Take care, everybody. Bye-bye.